If you've ever lived in a community with a homeowners association, you get that the relationship can be, well, let's just say complicated. It's this whole world of rules and fees and sometimes some pretty intense conflict. We're about to dive into a real-life legal showdown that shows exactly what can happen when things go way off the rails. So this is the story of Charlene Franks versus the Palms II Homeowners Association. And really, it's a classic David versus Goliath tale. You've got one resident who decided, you know what, I'm going to hold my HOA accountable. And not just for one or two little things, but for a whole laundry list of issues. No, you're seeing that right, 17. Ms. Franks filed a petition that laid out 17 separate violations of state laws and, get this, the community's own rules. This wasn't just some small squabble over lawn ornaments. This was a fundamental challenge to the way the entire HOA was being run. Okay, so to really get to the bottom of this, we're going to do exactly what the judge did. We're going to follow the evidence. And we're starting where so many of these fights begin. Just follow the money. Now, before we get into the weeds, you've got to understand the two key documents that run any HOA. First, there's the declaration. The best way to think of this is like the community's constitution. It's the supreme law, it's foundational, and it is really hard to change. And then you have the bylaws. Think of those as the day-to-day rulebook. They're much easier for the board to change on the fly.
And here it is, the single most important legal idea in this entire case. Just like a city ordinance can't override the U.S. Constitution, an HOA's little rulebook, the bylaws, can never contradict its big constitution, the Declaration. The Declaration always, always wins. Remember that because it's the key to pretty much everything that happens next. So, check this out. Here's our first big clash. The HOA board, they looked at their day-to-day rulebook, the bylaws, and saw, hey, doesn't say anything in here about a required annual audit. So, to save a few bucks, they just didn't do one. But they forgot to check their constitution, the Declaration, which was crystal clear. It said an annual audit by a CPA wasn't just a good idea, it was mandatory. So, of course, the judge saw this and it was a total no-brainer. Violation. The little rulebook can't just erase a requirement from the big constitution. It's a simple chain of command, and the HOA flat out got it wrong. And this same big idea, the constitution over the rulebook, it pops up again with something that affects every single homeowner, the monthly fees. The next big issue was whether the HOA illegally jacked up the monthly assessments. Okay, so that declaration, the community's constitution, it had a very specific rule. It said the board could only raise fees by 10% a year unless they got a full vote from all the homeowners. So let's do the math. The fee in 2005 was $139 a month. A 10% increase is $13.90. That means the absolute max they could legally charge was $152.90. But what do they charge? $153. And this is where the story gets kinda wild. The difference, the amount they overcharged, was just 10 cents. Seriously, a dime. 10 cents per homeowner per month. You're probably thinking, who on earth cares about 10 cents? Well, the judge cared. A lot. Why? Because to the court, that 10 cents might as well have been $10,000. The amount didn't matter. What mattered was the principle. The board had broken a fundamental rule from its own constitution. It was a tiny overstep, but it was still an overstep, and that's another violation. All right, so this case wasn't just about cash. It was also about power, transparency, and a homeowner's basic right to know what's going on. And that brings us to the next big chunk of allegations. Charlene Franks sure thought so. See, she wasn't satisfied with the tidy, summarized financial reports the board was handing out. She wanted to see the messy stuff, the raw data, the actual invoices, the receipts, the bids from contractors. The HOA told her, nope, you can't see those. So who was right? Well, for this one, the judge didn't even have to crack open the HOA's documents. Turns out, state law was already perfectly clear. It says that all financial records have to be made reasonably available. And yeah, all means all, including the nitty-gritty details Ms. Franks was asking for. The HOA refusing to show them? That was a direct violation of the law. And the problems with just basic governance kept piling up. The Declaration, that constitution again, required that anyone handling the association's money had to be covered by something called a fidelity bond. It's basically insurance to protect the community from theft or fraud. Well, turns out their manager, who was an independent contractor, didn't have one.
Just another box left unchecked and another clear violation of their own rules. Okay, so we've talked money and we've talked rules. But this fight wasn't just happening on paper. It got physical. It was about what residents had to look at every single day, the actual condition of the property. Now just listen to this phrase from the declaration. It's pretty powerful. It didn't just say, keep the place tidy. It set a legally binding standard, a reasonably high standard of care to reflect a high pride of ownership. That's not just fluff. That's a really high bar they legally promised to meet. And the evidence showed the HOA was nowhere near clearing that bar. Ms. Franks came with photos of a perimeter wall that was literally crumbling apart. There were huge, obvious patches of paint peeling off buildings. And here's the kicker. Both sides admitted these problems weren't new. They'd been sitting there, getting worse, for several years. The judge took one look at all that and agreed. This visible, long-term neglect, it did not reflect a high pride of ownership. This was a complete failure to perform one of the most basic duties of the board, a duty laid out for them, once again, in their own declaration. Chalk up another violation. So after digging through all 17 allegations, from accounting rules to peeling paint to crumbling walls, the judge had to lay down a final ruling. What was the final score in the battle of Franks versus the Palms II HOA? Now, this is what I find so fascinating about the final verdict. The homeowner didn't win on everything, not even close, actually. 12 of her 17 claims were dismissed. But, and this is a huge but, she prevailed on 5 absolutely critical points, the ones that went right to the heart of the board's core responsibilities: money, transparency, and maintenance. And her victory had real teeth. This wasn't just some slap on the wrist. The judge issued 5 concrete enforceable orders. 1, the HOA had to get that annual audit pronto. 2, they had to refund that 10-cent overcharge. 3, they had to open up their financial records to any homeowner who asked. 4, get that manager bonded. And 5, they had 6 months to fix the wall and paint the buildings. This was a real, tangible win. So if you boil this entire complicated case down to one single lesson, this is it. In every single one of those 5 proven violations, the HOA failed to follow the rules laid out in its own foundational document, its constitution. And for you as a homeowner, understanding what's in that document, that's where the real power is. And that brings us right to the final question, and honestly, it's the most important one. This isn't just some random legal story from Arizona. It's a masterclass in homeowner rights. So the real question I want to leave you with is this. Have you actually read your community's declaration? Do you know the rules it sets and the promises it makes? Because as Charlene Franks proved, knowing what's in that document can make all the difference in the world.